to the younger and better looking part of this team. I would like to adopt all of Mr. Harvey's arguments and to supplement, I have another case that factually in some ways is similar to this case. It's Saxton v. State, SAXTON, 300 Georgia Appeals 535. It's a 2009 case, and it's Mr. Saxton was arrested away from the scene on a murder warrant. During his arrest, a 9mm handgun was found on his waistband, which was not related to the alleged murder. And the appellate court granted a new trial in that case based on the admittance of the circumstances of the arrest, as well as his possession of the gun after the arrest. In addition, Your Honor, I think there's a tendency to think of this issue as a severance of the gun case to ensure that my client, Mr. Stillwell, and Mr. Nichols receive a fair trial on the murder. In my client's case, 2 murders. And I'm going to get to that in a second. But the other way to look at it is we also have to ensure that both gentlemen receive a fair trial on the gun case, on that count. I'm going to bring a case to the court's attention. Mims, M-I-M-S, v. State, 304 Georgia 851. That's a 2019 case. Miss Mims allegedly stole a car in Detroit, drove it to Atlanta. She allegedly committed a murder in Atlanta. She's arrested, charged on the same indictment, theft by receiving and murder, because she's caught in the car at the time of her arrest. It was the Supreme Court of Georgia found that the trial counsel was deficient for failing to move to sever the theft count from the murder. There was no argument that the theft offense and the murder were related. So there was no factual connection between those two things. There was and there was really no reason to bring the fact that Miss Mims was in a stolen car into the murder case, and there was no reason to bring the fact that Miss Mims was accused of murder into the theft case. Miss Mims was not, because there was overwhelming evidence of guilt for the murder, she was not given a new trial on ineffective assistance grounds for the murder, but she was for the theft charge. And the court noted that the jury's knowledge and understanding and exposure to evidence that she was involved in a particularly gruesome murder severely prejudiced her in the theft case, the theft aspect of the indictment. And, Judge, I'm not thrilled that Mr. Stillwell is on this indictment facing 2 separate murder charges, and I'm going to address that in a second. But I do plan on walking him out of the courtroom on these murder charges. But I'm also concerned about this gun charge. And we want a fair trial, and we want due process, and we want a jury that is not.
So, you heard Shaw just now. Let me know in the comments what you think about that. He sounds uber confident that he is getting Stillwell off of those charges, don't he? You heard him? Wow. That is crazy. Let me know if you already heard this part, because I never heard this part. Let me know in the comments what you think about his he confident like 9'4" Michael Jordan. You heard? He confident like 9'4" Michael Jordan or something. 07 Kobe. 2011 LeBron. He feeling confident, bro. Real
not
right.
Exposed to overly prejudicial evidence to consider that gun charge as well, because that carries time, significant amount of time, and we want a fair trial on that count. And so we're going to rely on the Mims case as well to ensure, hopefully, that we receive relief from the court and a severance on that basis as well. I'll also point out before I switch to the murder cases, that in anticipation of the state's argument, to the extent that they argue that the circumstances of an arrest and possession of a gun in and of itself is relevant somehow. Any cases that they cite, to my knowledge, are going to be older cases before we switched over to this new evidence code. And that argument really relies on propensity. The idea that, the fact that these individuals are proven to be gun-toting individuals by the circumstances of the arrest with an unrelated handgun somehow is relevant in this case. And for it to be deemed relevant at all, it would really have to hook on that would have to be the argument of propensity, which
in the camera
has
like
been
a nut.
Theoretically taken out of the purview of what we consider under the new evidence code. So I just wanted to add that as well, to keep that in mind, that anything that relies on propensity, not a good reason to let the circumstances of the murder in. I'm a little bit, Mr. Stillwell is in a different situation than Mr. Nichols in one regard, and that is that we have 2 murder counts and on this indictment. And so I asked for, Mr. Stillwell asked for the same relief as Mr. Nichols in regards to counts, I believe, 64 and 65, respectively, for each defendant. In addition, I asked for additional relief in my motion, which was severance of the murders. We obviously, for obvious reasons, want separate trials for each murder case. The courts have, in courts in Georgia, I was unable to find a case in Georgia that dealt with necessarily the joinder of 2 separate murders, but they have acknowledged the extreme prejudice of the admission of a prior murder into a charged murder trial in the similar transactions or other acts context. And for obvious reasons, I think the prejudice is very obvious. I think it's clear that the jury, upon inspection, it's not going to be lost on the jury that Mr. Stillwell is charged with 2 separate murders on this indictment. I think that the logical question that the jurors are going to ask and be confronted with is, so this defendant and his attorney are trying to tell us that lightning has struck twice. And that's something that really puts us in a position where we're fighting an uphill battle. And we believe that that deprives Mr. Stillwell of his due process rights and his rights to a fair trial under the 5th, 6th, and 14th Amendments. I would draw the case, I would bring this case to the court's attention. It is Bean v. Calderon, 163 Fed 3rd, 1073. It's 9th Circuit, 1998. There, it was held that the joinder of 2 murders and 1 indictment violated due process. And just to be clear, in this case, the Bean case, the murders were 3 days apart, 10 blocks away from each other. As you recall, Your Honor, in my constitutional speedy trial argument, what we're dealing with in this case factually against Mr. Stillwell, we're talking about 1 alleged murder on January 10th of 2015 and another alleged murder on March 14th of 2022. So we're talking about 7 years and 2 months separating the two. There's also a difference in the strength of the evidence in this case, which was a consideration in the Bean case as well. There's a difference in the strength of the evidence in the 2 cases against Mr. Stillwell, which leads to the prejudice against Mr. Stillwell, especially in the weaker of the 2 cases. In the 2022 alleged murder of Shamol Drinks, there's really only a grainy video and a video inside a store that shows that the state's going to say shows that Mr. Stillwell was in a store nearby and pulled out of that store shortly after Mr. Drinks. There's no eyewitness testimony, no ballistics, no forensics, no direct evidence at all that ties Mr. Stillwell to that murder other than his geographic proximity at around the time of the murder, according to the state, according to the videos. The evidence in the 2015 case, you heard about in your Honor, yourself in your ruling against me in the constitutional speedy trial argument, noted the complex and thorough investigation of that case. There are witness after witness after witness that gave statements of varying degrees. There's several, I think you heard of one of them, third-party confession type witnesses. So there's definitely a different quantum of evidence against Mr. Stillwell in each of these cases. And under the reasoning of the Bean case that I cited, joinder of those 2 cases would be constitutionally impermissible. And I'll just add also that in Bean case, they found that the jury charge that I know Your Honor is going to give, which is that the jurors should consider each and every count individually, was wholly insufficient to protect Mr. Bean's constitutional rights. So we are asking for separate trials for each of the murders, and we are asking for a separate trial for the possession of firearm count as well on behalf of Mr. Stillwell. Thank you, Judge.
All right. Mr. Floyd?
Yes, Your Honor. Thank you. it'll be no surprise that the state has a fundamentally different view on these issues. These severance motions are, to a significant extent, subject to the same type of argument that we have had previously on, I think, now 8 severance motions, where we've talked about general RICO principles, we've talked about the efficiency, the presumptions that govern, etc. And I'm not going to repeat all of that. You've heard it all multiple times.
Guns are a little different, though. So, Mr.
And so I was going to turn to the specific variations that we have here, to the extent they aren't the same as what we've talked about before. And part of that begins fundamentally, you heard Mr. Harvey talk about how counts cannot be joined simply because they are the same or similar. Same or similar was the exact language, the exact words that he used. And he said that if that's the only reason they're joined, then there's an absolute right to severance. That may be correct in some other circumstances. The state doesn't concede that, but the fact of the matter is it walks directly into the elephant in the room, which neither motion addresses in any way, which is the presence of count 1, the RICO conspiracy count. There was no mention of that count in any of the arguments. It was simply not addressed, as though if it were ignored, it would somehow go away. Not one case cited by counsel for either movement is a RICO case. And so why does RICO change this? Well, it changes it for several reasons, but the first of which deals with the definition of pattern of racketeering activity. Because when, and I've made the point previously that a pattern is not an essential element of the conspiracy claim. But that doesn't mean it isn't relevant at all. That doesn't mean the state can't introduce evidence of it, because the actual commission of racketeering activity supports the inference of an agreement to engage in that activity. And the granddaddy case on that is United States versus Elliott, 571 F. 2nd, 880, a 1978 former Fifth Circuit case, which has subsequently, of course, when the 5th and the 11th separated, when the 11th was created, that law became the 11th Circuit's law. The 11th Circuit has reaffirmed Elliott many, many times. So this evidence is relevant. And when you look at 1614.3, the definition section of RICO, subpart 4A, the definition of a pattern of racketeering activity, says engaging in at least 2 acts of racketeering activity in furtherance of one or more incidents, schemes, or transactions that have the same or similar intents, results, accomplices, victims, or methods of commission, or otherwise are interrelated by distinguishing characteristics. In other words, that is exactly not the rule that the movants are relying on for severance. Here, every defendant is alleged to be an associate of YSL. When we look at these murders, and we look also at the attempted murders, which were not mentioned in the severance motion by Mr. Stilwell, every victim in the murders that are relevant to one or both of these movants was an associate of a rival gang. And so just saying these acts are unrelated doesn't make it so for the movants. We have gang associates killing gang associates, trying to kill gang associates. We have them getting arrested shortly after murders and attempted murders with weapons in their possession. And the charges are possession of a firearm by a convicted felon who was previously convicted of a felony involving use or possession of a firearm. In this case, counts 64 and 65, 3 days after the murder of Shimel Drinks. So these are not unrelated. They go to the question of association with the enterprise. They go to the question of knowledge of the enterprise's activities. And in each case, each of these murders and each of these attempted murders, and the count 64 and 65, the individuals we're talking about were present with other members, other associates, of YSL. None of these are one-on-one murders. None of these attempted murders are one-on-one. And the arrests in possession, Mr. Nichols and Mr. Stillwell are together at the time. That is exactly what RICO says is related, and that was designed specifically to prevent this kind of severance, where acts committed in connection with association with the RICO enterprise by persons associated with it do not get chopped up, do not get severed. And when I say chopped up, I'm not kidding. I had a little trouble counting, and if I'm wrong, I apologize. But although the math is, the exact method of severance and reason for severance is not identical between Mr. Nichols and Mr. Stillwell, if you were to grant their motions as written, they would have 4 trials each. Okay? Because none of them says the RICO trial doesn't go forward. And none of them says the overt acts we're talking about that are also some of these counts don't come into that RICO trial. So the jury is going to hear that evidence. Even if you sever out a murder charge, even if you sever out a gun charge, it's still going to be heard as part of the conspiracy charge. So we get all the inefficiencies, but none of the supposed protections. But the motion just simply, they can't create a vacuum in which count 1 doesn't exist. And they can't create a vacuum in which count 1 and RICO don't serve the purpose they were specifically designed to serve. And I recognize that that may present additional difficulties for the defense.
Did you ever miss
but that
while
was
he
the
was on?
General Assembly's decision. And all the due process arguments that you've heard today have been made in reference to RICO. They have all failed. You've heard a number of due process arguments already in various contexts. But the fact of the matter is, Georgia RICO and federal RICO have survived every due process argument ever made against them. And that includes arguments arising out of severance motions. Again, the answer to this is RICO, and neither Mr. Stillwell nor Mr. Nichols have cited a RICO case, have cited a RICO provision, have sought to distinguish any of the grounds that apply here, or have sought to address any of the hundreds of cases that have rejected exactly the kinds of arguments we're talking about here. The idea that murders happened on different dates, have different victims, well, murders usually do have different victims if they occur on different dates. But that doesn't change anything here. In fact, that supports a RICO argument. Because part of what it is designed to address is people who commit multiple crimes over an extended period of time. That does not strengthen a severance argument. It actually weakens it. The argument that what the state is really using is a propensity argument, I take it that's meant to be 404B, gun toting, again, doesn't address the nature of the RICO pattern definition. If there is one of the organizing principles that RICO talks about, and those include the same or similar victims, we have that here. Every murder victim, every attempted murder victim, as to these 2 defendants, the counts we're talking about, is an associate of a rival gang. Same or similar intents, kill members of associates of rival gangs. Same or similar results, they are killed or they are wounded and survive. Same methodology, firearms are used. I'm not talking, none of the rival gang members are attacked in any method other than, outside of a jail, other than using a firearm. Okay.
He just posted it.
I'm just
And
posted up.
while it may be a propensity, we have the fact, one of the ways, if you want to show that you're a member of an enterprise, is you have a person who's got a gun conviction, and the first thing they do when they get out is they acquire a gun, and they commit another crime.
Cat.
That is consistent with the concept of enterprise, not antithetical to it.
Cat.
I can go on, but I think if the court has any questions for me to address, I'd be happy to do so. But the overriding principle here, I think, is this, Your Honor. Even if you severed out the counts they're talking about, all the evidence comes in the main conspiracy trial. They haven't given you a reason why any of it doesn't, which makes severance pointless. All the inefficiencies, all the problems I've talked to you about in earlier arguments apply. You simply end up with a series of complicated trials. The severed ones for these defendants might be somewhat simpler. They might not involve all of the evidence in count as would be in a trial in count one. I don't want to misrepresent there, but there would still be a ton of evidence that comes in for context and other reasons. They would not be simple trials. And therefore, the motions for severance should be denied.
Okay.
Yo, let me know what you think in the comments, man. Straight up. So that was Stillwell lawyer saying that he know for sure he gonna beat the charges. He was dragging, right? He's saying, I know I could beat the charges. And you know what charges he was talking about. I ain't gonna keep saying it, right? The state say he shouldn't be severed. What y'all think about that? Let me know in the comments. I thought that was interesting. That part I didn't get to see. Now the state comes in, and that dude right there, he not on the case no more. He mysteriously disappeared. He don't seem like he was that confident like he was right here, right? Now that's from like a year ago. Let me know in the comments if you've seen that before, or, you know, let me know. I don't know for sure, but don't sound like the judge was jacking it.
And yo, please don't forget to subscribe to the channel. Leave a comment letting us know if Thugger is going to make out, or are they going to cook him like cheap chicken?
He just posted up.